We're like, I just didn't Oh, you do. I nothing. Staying in. No.
All right. Welcome back. Welcome back. We're almost done, my friends. We are no woo, right? You got a little work ahead of you, but we are more or less done. Today's class 25. Next week we have class on Tuesday. We'll do more on landlord tenant. Class on Thursday, landlord tenant. And then on Tuesday the 26th, basically 12 days from today, is our last in-person class. My goal for that last class is to go over one of my old finals. I haven't decided which one yet. I'll tell you in advance. And that's it, folks. So it's, if you rush in, you get to know me, then you vanish until graduation. So you see how this works. It's true. It's a weird thing. There are a lot of students who I see them as 1Ls, and the next time I talk to them is at graduation. So it's just weird parts of the job. Oh, you're here today. Good. I gave you praise last week by text. I think you got it from Arturo, but I'm glad you got that. So thank you for that. Yeah, there are lots of things in the book I don't like, and occasionally people spot them. Okay. Questions on leaseholds, on tenancy at will, periodic tenancy, term of years. Any questions? No? All right. Let us try some sample problems. I have these on the board. Please sign into the clicker. And if you have your name cards, it will be helpful for me as well. Let's try question number 1. And who's up next? All right, Kira, you're up next. All right. Let's try question 1A. See how we're doing with this one. Give me a moment to start. I see 9 people on Zoom, so that means people are legal writing project something to do this week. Hi, guys. I see you. Actually, I don't see you see me, but you know what I mean. Okay. All right, so question 1A, and you guys at home can play along. All right, someone's giving me a thumbs up on YouTube. Very, very funny. Don't give me a thumbs down. Don't hurt my rating. No, just kidding. Just kidding. All right, question 1A. I actually don't read any of my comments. I don't check any social media comments at all. I haven't checked my Twitter notifications in almost 3 years. Self-control. I stopped checking them in 2020. I don't use Twitter at all. I have an account like 20-something thousand followers. I don't check it. It just doesn't exist. I get off it. It's dreadful. Even if Elon buys Twitter, get off it. It's a dreadful place. Awful. Do not read YouTube comments. Those are the freaking worst. Those are the worst. I've actually blocked YouTube comments, but they keep coming back. You can't avoid them. Anyway, poor Kira doesn't care about any of this, right? So Blackacre from lessor to lessee. Just to know the terminology, Kira. Who's the lessor and who's the lessee? Just who's who here? How do you remember them? Correct. Correct. The lessor is the person who gives the lease. Lessee is one who receives it. The way you remember this, EE, the suffix is receiving, OR is giving. Lessor gives, lessee receives. Okay, good. So Blackacre from lessor to lessee for 1 year, beginning October 1st, comma, then to A and his heirs. What interest does A have? Reversion, remainder, or none of the above? There is no D. Someone put D earlier. D is not a choice. That's not an option. I swear they do this just to mess with me. It's just anyway. Okay? So take another 10 seconds. I'll come back to Kira. Yeah, I know when the Zoom numbers go up, that means people are doing a legal writing memo or something. Okie doke. All right, Kira, help us out here. So first off, what kind of leasehold do we have in example 1A? How do you know it's a term of years? Correct. It's a fixed duration. It's a term of years lease. Okay, so there's a term of year lease lasting 1 year, and then to A and his heirs. Who has the present interest here, Kira? Okay, and what is his present interest? Good, exactly right. Okay. Who has the future interest here?
A.
Does the landlord have any future interest here? Okay. So what future interest does A and his heirs, or what interest does A have here? How do you know it's a remainder? Perfectly stated. Excellent. A plus, right? It's a future interest that follows a natural termination, goes to a third party. That's remainder, right? Nothing new. The answer here is B, remainder. Okay. Not bad. Some people put C. Anyone want to call up, explain why C? A couple people put earlier C. They didn't tell me why. They wouldn't admit it. But what's none of the above? What were you thinking? Maybe the question's not good. Yeah. Not only a life estate. Remember we revised that definition? See, you're not wrong, right? So earlier I said following a life estate, but that was like the sort of intermediary definition. I gave you a revised one following a natural termination of any present interest. The reason why I did that was to account for the term of years, right? There are different types of natural terminations that are not life estates. Not many, but there are some others ones. Okay? Any questions on 1A? Let us do 1B. For Hunter in a moment. Okay. 1B. Blackacre from lessor to lessee for 1 year, beginning October 1st, period. What interest does lessor have? Okay, another 15 seconds. Okie dokie, Hunter. What's your answer here? Why is it reversion?
Because it's a future interest that follows the natural termination of the present interest, which would go back to the lessor with the transfer.
Correct. How do you know the future interest goes back to the transfer? It doesn't tell you.
It pretty much infers from.
Correct. You draw an implication. That's right. Right. This is not for you in general. Infer versus imply, right? To infer is I am inferring something to you. I am making. I am. I'm sorry. To imply versus infer, right? I'm implying something. I am telling you, here's what you should be doing. Infers, you're inferring from me. So just make sure you get the direction right. You're right. Okay. You have to sort of infer from the conveyance that it's got to go somewhere, and you infer that the future interest goes back to the transferor, the lessor. This is a reversion. Wow, that's good. I don't get 100 very often in anything. That's good. You're all right. Good. The other class was in the 80s, I think. So I hate comparing, but it's so easy. It's there and it's fresh in mind from a few hours ago. I know you're texting me like, haha, we beat you. I know. All right. Good job. 100%. Good job. All right. Don't forget your remainders and reversions, because on the exam, I very often mix up future interests with leaseholds. It's very easy to do. And I sort of combine them. And then you have to sort of piece them out, right? You can have a remainder in leasehold, right? You can have a remainder in term of years. It does not have to be a remainder in fee simple. I can get real nasty. I can get really creative with this. Sorry, it's true. All right, number 2. This is me for Gabriel in a moment. Let me read it. It says, on October 1st, 2020, Larry leases Blackacre to Tom for 1 year, beginning on October 1st. And by the way, why L? L for landlord, Larry, T, Tom, tenant. I'm not that creative, okay? On October 30th, Tom moves out without giving notice to Larry. The question was Tom required to give notice? Yes or no? Okay, another 10 seconds. Good. Gabriel, what's your answer here?
Yes.
Why do you say yes? Uh-huh. Okay. When did he say he wanted to terminate the agreement by? When was notice given? I'm sorry, when did he move out?
He moved out.
No, read it. Read it. So on September 30th, he moves out. Yeah. Want to try again?
Yeah, he moved out the day before.
Not the day before. What is the last day of the lease? Yeah. How many days are in September? I don't have a map up here, a calendar. So Gabriel, try it again. How many days are in September? 30 days in September. When did this lease run out, my friend? It starts October 1st for 1 year. When does it run out? And when did he move out? Was there any requirement to give notice here? What's the answer? Okay, the answer is no. Okay, good. 70-30. That's not bad. But you see what I did here, right? He's correct. To terminate a term of years early, both parties must consent. But in this case, there's no need to give notice because he left on the day the lease finished. So be attentive not only about the requirement of time for notification to end it, but also when the lease ends. I can trick you on this one very simply. But as a general matter, Gabriel, I'll just ask you a follow-up. What would have happened if he left, September 1st? Or make it easier, August 30th? Would he still have had to pay the rent for September 1st?
After the end.
No, he left August 30th.
August 30th.
Would he still have to pay September rent? Yeah. He would, right? Merely leaving is not enough to terminate it. So, everyone get this? Okay, good job. I think this 7% was better than the other class, but I don't recall. I know it wasn't 100, the other one. All right, 3A. All right, this will be for code in a moment. All right, 3A says, On October 1st, 2020, Larry leases Blackacre to Tom from year to year, beginning on October 1st. On September 30th, 2021, Tom moves out without giving notice to Larry. In this question, was Tom required to give notice? Okay, take another 15 seconds. Think about this one. Okay. All right, Dakota. What is your? Oh, by the way, before we get to your actual answer, what kind of lease do we have here? I'm sorry.
Or an at-will, I guess, or you're-
Oh, you're giving me different answers. What kind of lease we have here, my friend? Read it. It says Larry leases Blackacre to Tom from year to year, beginning October 1st.
Term of years, because it doesn't say anything about it being terminable. for any party.
What does year to year mean?
It's just every year the lease renews.
That's not correct, Kevin.
It's a periodic,
Why is it periodic?
because
Yeah, I'll come back to you, Dakota. When you see the phrase month to month or year to year, what kind of lease is that? Louder?
periodic,
Periodic. How do you know that?
because it's only for that set period, for the month. And it's essentially like,
What happens at the end of one period with a periodic tenancy?
the lease is technically
No, that's not correct at all. It renews automatically.
over. Wouldn't it have to be over for it to renew?
No, with a periodic tenancy, if it's month to month, at each month it renews, doesn't end. All right, so I'll go to you, Kevin. All right, so we have a periodic tenancy, begins October 1st. He pieces out on September 30th, no notice. What's he required to give notice here, Kevin?
Yeah.
What-
It's in common law.
Why? Would it matter if it's common or
Well,
modern?
no, it matters because it renews every year to year. You have to give notice at some point in time prior, or else it will just renew when that date.
Correct. Correct. If he does not give notice, he's in trouble. So now let's go to question 3B. This will be for Turo in a moment. 3B. Same facts, but the question is actually different. Year-to-year lease begins October 1st. He wants to move out September 30th. That's his goal. When must Larry give notice to Tom in order to move out on October 1st? I see you're all counting, which is good. Get your fingers out like this little piggy, right? You're counting. I love this. You're all counting. It is great. One potato, two potato. You know that song? One potato, two potato, three. You know that song? Coco Melon. If you don't have kids, you'll know Coco Melon. You know Coco Melon? Oh my God, it's brain numbing. Oh my God, so many hours on loop on Netflix and stuff. All right, Arturo, save us from our Netflix drama. Okay. All right, okay. 10 more seconds, then Arturo. All right, I'm gonna stop it here. We can move on. What was that? I heard. Oh shoot.
My answer's not even on.
Well, that's not a good sign. The answer's not on there. I think you're in trouble. There's no choice F. That's not. That's okay. All right, Arturo. So let's walk through this one step at a time. Okay. We have here what kind of tenancy? Periodic tenancy. It begins October 1st. Okay. When does the first period end? September 30th. That's right.
Yes, September 30th.
Okay. Well, actually, the first term was September 20th, September 30th, 2020, and the second term would be September 30th, 2021. Right. See, it begins October of 2020, and he wants to end in 2021. Right. So he actually did a complete term from October 1st, 2020 to September 30th, 2020. I'm sorry. Sorry, New Year's, right? So he wants to finish the term September 30th, 2021. Okay. When must he give notice to vacate on that date?
So, how often is the term located? Cannot exceed 6 months prior to September 30th. You're counting months.
September 30th.
Oh, yeah.
That's correct. March 31st. That's who we did. Oh boy, that's pretty damn good. 80%. That's a lot better than the other class. I think the other class was 60. What were you thinking? No? That's fine. That's fine. I didn't mean to, I'm sorry, I didn't mean to put you in the spot. All right, let's count. Ready? So what you need, hands up. You need 6 full calendar months, right? At common law with a year-to-year lease, you need 6 full calendar months. So let's work backwards, right? We need September, August, July, June, May, April. So you need 6 full calendar months, April. So the latest possible date that you can do notice would be the final day of March, which is March 31st. Yeah, oh, please. Yeah, without the fingers, yeah. Okay, but that's not as much fun as this with the fingers, right? Look, I have to, if you can do that in your head, that's great, but not everyone can do that. Look, I got you've got the exam do with this finger, the proc's like, what the hell are they doing with their fingers? Right? But you got to count backwards, right? September, August, July, June, May, April, 6 full months. So then the last day of March is the date you have to give notice by. Okay.
So I was like, other way. October. I ended up counting October because
No, the lease is over by that point. Yeah, you count September.
I was like, I started when it started, like, okay, 6 months into
The full month of September, because by October 1st you're trespassing, right? You can't be there anymore if you want to give notice. Is there a hand over there somewhere, Tony?
Like what he said, counting backwards. You need to count backwards. But I got the right answer, but
You can do forward or backwards. I think backwards might be easier, but you can do forward. If you have a calendar, you can just look at your calendar. What was that? Look, you can do, again, I told you, the exam's open book. Bring a damn calendar, right? Bring a calendar, 12-month calendar. I don't care, right? Whatever you want in there. Put your birthday, put Christmas, whatever you want in there. Put the calendar in there. But count your days. All right, but this is good. 80%. I'm actually pretty happy with this. Like I think the other section was not that high, so that's good. Unless, I mean, look, but it's always like you probably ask your friend for the answer, so it's unfair to compare. But anyway, it's not, and I know it's on YouTube. It's not like you can't cheat, right? What's that? I know it's not easy. I'm with you because it's so easy to make a mistake, right? Yeah. Easy to make a mistake. So that's why if I tell you would it make you better if you have a calendar in front of you?
Yeah, I'm gonna have one.
Good. You're allowed. I'm giving you full permission. Look, it's law school. You got to do what you got to do to survive, right? You got to. There's survival behavior. Bringing a calendar to an exam is fine. Like I remember on my contracts exam, we had to calculate damages without a calculator. And he never told us we'd have to do that. So we're all just like panicking. What the hell is this? And it was I think my first exam was a 1 hour. Like, how do I? Anyway, so we did it. But so yeah. You have to calculate damages for a contract exam? No calculator? Yeah, now there is. We didn't have one back then. There were no. Oh, it's only available for limited time. Is that the idea for certain questions? I see. Oh, I see. See, I disabled spell check. Don't hate me, right? And the reason why I think spell check may actually give you an advantage, because if you're not sure like what a word is, it might tell you the right answer. You can kind of futz around. So I think spell check's an unfair advantage. But I allow copy and paste and cut and paste. When I took the bar, it's a true story. It was on a computer, but cut and paste was disabled, right? So what did this idiot do? So question 1 had 5 parts, right? So I put part A in the box for number 1 and part B in the box for number 2, and they got to the exam, and there's like 15 more questions. So I was supposed to put all question 1 in 1. So I just put everything in the last box. I couldn't cut and paste, so I put basically the entire bar exam in one box. I was like, they'll figure it out. Very fast. Look, I couldn't cut and paste. If I tried to retype, I run out of time. So I was like, all right, they'll figure it out, and they did. I put a note. I called the roving whatever proctors they're called. They weren't help. But yeah, there was no cut and paste. That I thought was unfair. There's no reason to disable cut and paste. But anyway, but no spell check. I don't think you did a calculator. Maybe there's a calendar function. I don't think there is. All right. Everyone okay with 3B? Okay. Now let's do 3C. This will be for Bree in a moment. It's following from question 3B. So let's say Tom does not give notice by March 31st, right? If Tom fails to give timely notice, when will his lease terminate? Oh, I gave is multiple choice. No, I'm sorry, it's a fill-in. There's no choices. Fill it in. I'm sorry. If I give you the choice, it'll be too easy. So just fill in the date. The format doesn't matter. You'll know what you put. Yes, I'm looking for a date. Not. I'm gonna shut my mouth. No, it is just he fails to give notice. No notice at all. Well, no time limit. Let's say he gave notice on April 1st. Let me rewrite this question. Let's say if Tom, the reason why I didn't put this here is because I put a date here. It will give you the answer for this one. But I'm telling you now, he gives notice on April 1st. How about that? Good. Yeah, I actually thought about that. I was like, but if I give you a date here, it'll screw the answer up over there. So that's why I didn't do it. That actually, I thought. Okay. This will be for Miss Bree in a few moments. One potato, two potato, three potato, four. Okay, Bree. When will his lease terminate? Correct. Very good. September 30th of 2022. Why is it September 30th of 22? Gosh, let her speak, please. Yeah, go ahead. Another period, exactly. So one more year. Who wrote never? That's not. I mean, well, okay. You know what? Before we put this, I mean, I wrote timely notice. I mean, that was a hint, but fine. But yeah, September 30th of 22. I think enough if we put that. It's not October 1st. I was looking for that one. It's not October 1st. The lease ends on the final day of the month of September. It doesn't go to October 1st. This one is not correct. Yeah, a couple people put October. No, it's not October. It's September. Okay, close enough. Correct. Yes, end of the day. Good. Someone November, October 30th. There are a lot of wrong answers there. Okay, but the correct answer is September 30th of 2022. It is one full period more. Okay. On October 1st, he's out. If he's there at the stroke of midnight, he's trespassing, right? He turns into a pumpkin or something, right? You can't stay there past midnight. Yes, Kevin, is that a hand?
Yeah, just questioning something though. If they said it on April 1st.
He gave notice April 1st of 2021. That's correct.
So the full month of April counts. It doesn't go into April 2nd, and then we're.
Well, but it doesn't matter. Let's just count. Okay, so April 1st, May, June, July, August, September, October. He's given sufficient 6 months notice to vacate by the following year, right? It's by the following year, right? Because he's basically giving like 18 months notice, basically, more than enough. But he cannot leave by 2021. He'll leave by 2022. Yes, Rieger.
This is a hypothetical. Let's say someone's living in a year-to-year lease and they give an end date 5 years in the future. Wouldn't that in effect just make it a period, not time of term of years lease?
No. I mean, because there's no requirement. In other words, that's the option of the that's the option of the tenant. I don't think there's any problem with doing it. Yeah. I mean, I suppose you could say that you cannot give that much notice. Now, what might be tricky though is let's say you tell the landlord, I want to move out in 5 years. It's like, well, I want you to move out next year. So I think the landlord could count with an earlier termination date. And so long as there's 6 months period, you can do it.
If you revoke a termination, are you still required to leave, or
Who's revoking the termination?
the lessee revokes timely? Is it
I
out of
don't think
tenancy?
you can. I think you're sort of bound by it. Well, let me say it differently. Like once the tenant gives notice to vacate, he can't say like, never mind, because in theory the landlord maybe found a different tenant and it has something else lined up. So, this is not like the Supreme Court where you announce your retirement in advance and actually take it, right? You have to. I think you have to stick with what you do. Yeah, it's a weird thing. I mean, Justice Breyer, he's still in office, yet there's a justice in waiting. It's not clear how this actually works. It's very strange. I mean, you can't be appointed to a vacancy that doesn't exist. So it's strange. Monet, your hand was up.
Yes, so, and all these problems is to give notice to terminate the lease at the original end date, not to terminate early whenever you decide.
Right. If you want to well, you can do that, right? Let's say, Monet, let's go back to question 3B. And let's say he gave notice in February, right? It would still end, though, on September 30th. It doesn't matter when you give the notice with this year-to-year lease. It's going to end September 30th. That's the date. Yeah. So if you even give the notice in February or January, it doesn't really matter because you need to have a full period. I think the only way to end it earlier than September is if both parties consent. If they both consent, that's fine. You're allowed to do that. They want to leave like in August or July. All right, we go to question 3. Let us do question number 4. See what happens here. And this will be for Jocelyn. Moment. Okay, number 4. This one's a little bit trickier. It'll take a little bit more time, I think. On October 1st, 2020, Larry leases Blackacre to Tom for month to month. The rent is $100 per month. On June 15th, 2021, Tom notifies Larry that he will vacate on July 1st. July 1st, Tom vacated Blackacre and stopped paying rent. On October 1st, 2021, Larry leases Blackacre to Sally for $100 a month. Then Larry sues Tom for the unpaid rent from July, August, and September. At common law, how much does Tom owe Larry?
What's the short answer?
Oh shoot! I'm sorry. Just forget this one. Let's do multiple choice again. I'm sorry, guys. Thank you for correcting me. Thank you, Clark. Let's try this again. If you put it in, just do it again. At common law, how much does Tom owe Larry? 0, 100, 200, 300. All right. I guess you're all counting in your heads. Ooh, okay. Jocelyn, you ready? Okay, I get thumbs up from Jocelyn. All right, we'll stop it here. All right, so Jocelyn, first off, what kind of lease do we have here? Okay, and what's the duration? What's the period of this lease? Okay, we have a month-to-month lease. It's a periodic tenancy with a month-to-month duration. All right. He gives notice on, was it June 15th? On what date can the lease terminate here if you give notice on June 15th? Full calendar month. She's correct. Okay. So if you give notice on June 15th, a full calendar month must occur before you can vacate. So the lease would basically end July 31st. Okay. The apartment then is vacant in July, August, and September. So Jocelyn, the question: how much money does Tom owe Larry here for the lease? That's pretty good. The answer is B, $100. So there's a couple things with this question, right? The first, you have to understand, when does the leasehold end? The leasehold ends on July 31st. So only 1 month is due. But the other issue is about a duty to mitigate, right? Here, the landlord rented the apartment in October. You can't double dip. That's an unjust enrichment, right? So you cannot you cannot charge Tom if someone else is in the unit. So the answer is 100. Okay. Pretty good, actually. Anyone want to, what they thought otherwise? Put C or D or A? Sure, boy. If I'm sorry, he leased it immediately. So as soon as, okay, so Tom leaves June 15th. I'm sorry, Tom leaves July 1st, and he immediately puts a tenant in there. You could not, and Sally paid the rent in July. I think the only difference is, assuming the rent is the same amount, he couldn't, Tom. I mean, imagine Sally pays 75 and instead of 100, then I think Tom would have paid the difference of 25. But you're exactly right. Good question. Yes, Arturo.
I can imagine a world where good double dip. So in this case, let's say Sally gets into July 1st, and there was a periodic tenant fee, they just agreed, you just, hey, you want to pay the last month's rent for early. And someone else.
He paid the July rent. So this is going to be hyper technical, but if Tom is paying the July rent, that's his apartment, and the landlord couldn't lease that to someone else, he doesn't have the present interest. Now, he might do it anyway, but I think that'd be illegal. And I think if the landlord rented out the apartment that Tom was duly paying for, Tom could sue the landlord for compensation. And to make it even more precise, if Tom has the present interest for July because he paid that rent, and Sally comes in, he can call the cops on her because that's his superior interest, right? The landlord. This is almost maybe like the next case, right? The case from Virginia. It's yours, and you can't rent that apartment that belongs to someone else. Alexa?
Like, if Tom is leaving, like, I guess, evicted him and finished the collection, so like it's debt for him, but they have to.
Well, I know. I'm not sure what you mean. The lease ends July 31st, right?
Right.
So then what's with collections?
Well, let's say if he left, if he didn't pay, like, I guess for the $100, and then she moved in, but he didn't pay, would that still be his apartment since it's his debt still, even though she's.
Well, again, so there are two different things, right? If he gives notice June 15th, it's his apartment through July 31st, no matter what happens. The landlord can't rent it out before July 31st. Do you agree on that much? No, they can't. I mean, that's illegal. I mean, landlords do a lot of shady stuff, right? But you can't rent out an apartment that belongs to someone else. In theory, at least, the tenant can come back, Tom come back and sue him for a breach of the lease, which would probably release his obligation to pay the rent. Question, Nick? Okay. All right. Any other questions number 4? Behind me, I wrote on my back. I'm sorry. That's not nice. Putting my back to students. I'm sorry. I should stand over here. Let's not like this corner. Questions? You ever go to a concert where you sit behind the stage? You ever do that? It's weird because you're looking at the backs of everyone. Like the Astrodome or the rodeo, they rotate, which is kind of nice. But there's some stadiums you're actually behind the concert stage, and that's not pleasant. At the Kennedy Center in Washington, D.C., you can actually sit behind the orchestra, which is kind of cool. They're called the chorister seats, like where the chorus usually sits, but you can sit there for a conference, which is kind of nice. All right. Many years ago, I actually saw Justice Scalia and Brian Garner at the Kennedy Center. That was cool. They did a session on legal writing. It was once in a lifetime encounter. It was like a 3-hour discussion on legal writing. Their book, Make Your Case, had just come out, and they had offered like a certain number of tickets, like for students. They got there really early. We got tickets. So see Scalia and Garner at the Kennedy Center. It was very, very cool. All right. Questions on number 4. All right. Number 5 for Vicky. This is actually a segue to our first case. Right on schedule, 40 after. Okay. Okay, here's the question. O conveys Blackacre to A in fee simple. A enters Blackacre and finds that the property is condemned and he cannot live there. At common law, A can rescind the purchase. True or false? Okay, another 10 seconds. Put your answers in. Okie doke. All right, Vicky, what's your answer here? Okay, why'd you put false? Vicky, what's the difference between actual possession and legal possession? Actual possession and legal possession. What's the difference? If this place is condemned, imagine there's like yellow tape around it, right? You know, it's all in bad shape. He can't like even live there. Does he have actual possession of the property? Or does he have legal title to it? Okay, so what's the difference between actual possession and a legal possession? Yeah. Legal relationship, right? Okay, very good. Thank you. All right, so the answer is false. The common law is harsh, right? You might think when you buy Blackacre, you're getting something you can actually use, but you're not. All you're getting is a bundle of sticks, right? And you, oh boy, look at that. Like a coin toss. Like a coin toss. That's very good. Lloyd. A can rescind the purchase. No, it's a statement. Is this true or false? But if I say can he, then it must be yes or no. Would you prefer yes or no? Is that what tripped you up?
I looked at it.
So then I'm not sure what you're asking. Right. If it's a question, it'd be yes or no. If it's a statement, it's true or false. Curious. Trey. You flipped your name tags on me. Don't mess. You're messing with me. But I could fool me on this one. Yeah.
I thought it was true, because I thought at common law, you're supposed to include your title, be pretty clear of like any.
Legal defects. Yeah. The point I'm trying to get across is,
Doesn't that take away your possession state?
you can possess it, you just can't use it, right? So what's weird about this is, let's just say there's a toxic waste dump on your property, right? And the government says you can't use it. That's still a valid contract for sale of property. Kevin.
So I got the answer right, but I think you got it right for the wrong reason.
Uh-oh.
Condemned. I think I'm confused about what that actually means. So
You know what?
Property is condemned, you still own it. Like.
Yeah.
So
I meant the government basically says you can't use it. You know what? I'll rewrite the question for next year. Maybe it's a bad question. Okay, I'll take it. Maybe it's a bad. That's why I went to multiple choice questions. I didn't really explain. Because the thing is, if I explain what condemn means, I'd have to give you all these other things to kind of go with it. You know what? I'll scrap the question next year. Sound good?
Yeah.
Yeah, okay. I'll delete it. Any question that yields a 50-50 split is not a good question. I gotta rethink that one. True. Bye-bye. Okay, gone. All right. And I've never had, really, if you had a question that's 50-50, it's a crappy question. Thank you, Tony. I'm glad you agree with me. Look, I want you to be honest. So that's good. No, seriously, if I ever write a question that's 50-50, I got to trash that question when you write it. So, all right, forget I ever asked it. I deleted the questions. Go on.
There's actual possession without legal possession, technically legal possession.
Whoa, say it again.
So I feel like legal possession was built into actual possession. But is it possible to have actual possession without legal possession?
Is it possible to have actual possession without legal possession? I don't think so. I think legal possession is sort of like the floor, right? You need to have the right to even enter without considering a trespass, right? But think of our next case. Even if you can enter legally, there might be someone occupying it already, which denies you actual. Daniel, then Tony, then Arturo.
Wouldn't someone living on the property before adverse possession be actual possession without legal possession?
All right, so you'll do adverse possession in property too, but I'll give you just a mini preview. If you are in the property as a leaseholder, it's not adverse. It would only become adverse the minute you hold over. And in most jurisdictions, you need 5 or 10 years. So staying over by a couple days is not going to cut it. Okay, Arturo?
When is that element?
A bailment?
Yeah, you have actual possession. Or let's say, sorry, an involuntary. Find something. Don't real.
No, it is legal, right? A bailment is a legal relationship. I'm not sure I agree with that, right?
An involuntary, we find something.
But I think that's still a duty of care. I think it's still a legal relationship. I mean, it's not the full bundle of sticks, but it's a legal relationship, like any other duty of care. Yeah, good question. I hadn't thought of that. It's a good question. Yeah, I mean, a bailment, imagine like you drop your ring on the floor or something, someone picks it up. Under the law, there's a legal relationship. You have a duty of care not to treat it negligently and damage the ring or whatever. Yeah. In other words, if you take it upon yourself to safeguard the ring and you are negligent in your duty, you can actually be sued by the true owner. Yeah. It doesn't matter where you find it, right? If you actually consider yourself a bailee, then you're a duty to take it. I mean, you don't have to. It's like with torts, right? Remember the lifeguard? If you fail to rescue someone, it's not a problem if you're a lifeguard and you don't rescue someone, you can actually be liable for it. You take on a duty of care and your responsibilities for that. What's that?
And if you leave them in a position to.
The worse off, yeah.
Yeah,
Yeah. Yeah, I mean, if the ring had just stayed there on the floor, nothing would happen perhaps. But if you take it and you damage it, the ring's even a worse spot than if you just left on the floor. But of course, someone else could have stolen it, so you don't know. But let's move on, okay? It's a good thought. All right, first case. Tony, let's talk about a crappy case. Hannon versus Dush. Where are the facts here, my friend?
Basically, Hannon, he entered into a lease with Dush.
Say no. Say Dush, please. In the other class, I said Dush deliberately. In the other class, the other one's worse. Dush. Thank you. There's a case next semester. The last name is Kunto. Kunto. Or is it Kunto? I say Kunto, right? So, Dush, please. Thank you.
Entered into a lease agreement with Dush, and when he showed up to take possession of the land, he could not get into the property, and the whole issue before the court really was whether the English rule applied or the American rule of, does the.
Okay, so yeah, let's break down. So a guy moves into signs a lease. He shows up on day number 1. There's a holdover tenant. We call that what kind of tenant, Tony? What do you call the tenant? The holdover? What's that phrase? Rieger?
At sufferance?
Tenancy at sufferance. Yeah. Okay. Good. So the tenancy at sufferance. So Rieger, just for a moment, what's the relationship between the landlord and the holdover?
And the holdover?
Yeah. If it's a tenancy at sufferance, what can the landlord do?
The landlord can begin eviction proceedings against the tenant, and their tenant is still on the hook to actually pay the rent while they're there.
Okay, so he can either move to evict or what? What's the other option?
Just make it a period.
Correct. Right. With the holdover tenant, the landlord can either evict or basically deem it a periodic tenancy, right? Which would extend month to month or year to year, whatever it happens to be. So Natalie, does the landlord move here to evict the holdover tenant?
No, he doesn't.
He doesn't. What do you think he's doing? You're not supposed to do?
He's double dipping.
Double dipping, right? I think you're exactly right. We don't know this from the case, but if I had to guess, he thought, oh wow, I can collect rent from this other guy and from the new guy, etc. Now, you did the flip. I didn't name Carissa, right? So Carissa, what should, or legally, what should the new tenant have done here when he sees the other guys holding over? What could he have done?
Gone to the court and maybe gotten them evicted or like,
Well, could he actually evict the tenant?
I don't think so, he has ownership of it.
But is he in privity with the holdover tenant?
No.
So what should the new tenant have done in this situation if you want to give good legal advice?
I mean, what he did do, right?
I know what he did. I'm asking what should he have done? In other words, if you go to, if you own a piece of property and there's a trespasser there, call the cops. Call the cops. Right? Isn't that the easiest thing to do? You say, look, I have a lease. It says I am supposed to be here starting with October 1st, right? There's a trespasser. But instead he goes and he tries to sue the landlord. Arturo, is that a hand? They will not do anything. That's right. Right. And then you have to basically go to court and file an ejection action against the tenant holdover. Right? That you can do, right? Okay. But just calling the cops may actually grease the skids, so to speak. People get scared. Tony?
Back in the when this case took place, could he not have got him?
Self-help. I just was going to ask that. That was your question, right? Yeah, I mean, self-help was always risky, especially when you're the one on the outside of the house. Because look, let me put it this way: there's a dispute over who actually had title to the property. I would not want to raise a castle doctrine argument with his uncertain title, right? Because maybe the holdover tenant was actually entitled, and that's what you're just committing murder. Yeah. So I would put the gun down and maybe call the sheriff. Maybe, I don't know. There's a hand here, then to Kevin.
Why can't the cops do anything?
They can, but they won't. And the reason why is that in most jurisdictions, there are protections for people in homes that you can't remove them without some judicial process, and that's the eviction process, right? But the weird part is, it wouldn't really be an eviction. It'd be basically a trespass action. You would go to the court and you would seek a judicial order saying he's trespassing. It couldn't be eviction, to Chris's point. They're not in privity, right? There's no legal relationship between the new tenant and the holdover, I think, at least. Kevin, then Arturo.
Yeah, I was gonna ask that question. First you say that you were then there. So if he's trying to move in, you're not able to call the cops, with court order, all that stuff. Then I guess it would be vicariously through the tenant.
You would probably sue the well, this is the thing though. Under the rule that the Virginia court adopts, the American rule, there's no cause of action against the landlord because he has no duty to actually put you in actual possession. He gave you the bundle of sticks, right? So maybe there's a fraud claim or something else that he misled you, but there's no property claim. Yeah, this is a good point. I'm sorry, putting it back to you, right? Very often in property class, the cause of action is actually fraud, right? If you lie, that's fraud, but there's no actual cause of action for failure to put you in the property. Yes, Arturo.
I don't know if this is a Texas thing or a Dallas County thing, but if they're there over a day, they're not considered trespass. They're considered to be living there somehow, some way. Maybe it's even just.
I've not heard that. If you can send me something, I'm happy to look at it later. I've not heard that.
Yeah, so
that seems very convenient.
Yeah, very.
For trespassers?
There's a holdover there that's been there for over a day. They're technically staying there, and you have to evict them. The police won't do anything about that.
Right, but I think the general is the cops don't do anything. They want a court order.
Yeah, that's.
Yeah, I mean, the actual rule is the sheriff will not do a damn thing unless you have a court order because maybe you're lying, right? Maybe there's some misunderstanding, and in theory, at least a neutral judge can sort out who's actually right.
Yeah, the sheriff will do it, like police.
Come on, Rieger, then Tony.
In the event that Hannon was to do the right thing, call the police and try and start eviction proceedings against homeowners, would he still be on hook for rent because presumably the holdover is on hook for rent at the same time?
I think it would depend if the holdover actually paid rent. So with the tenancy at sufferance, if the holdover makes a rent payment, that can implicitly create a new period, right? If in other words, if there's a holdover tenant and a tenant hands him a rent check on the first of the month and he cashes it, that's basically an implied agreement to continue periodic tenancy. So if the landlord cashes the check, he can't collect rent from the other guy. But of course he can. They can do shady stuff. Tony, what's your question?
So that just see if they have to get a court order and all that, that just seems like a pretty advantageous move for a holdover tenant or somebody because that can take some time.
Well, we'll do eviction in class next week, or I guess on Tuesday. Eviction can be done quickly in some jurisdictions. Like in Texas, it can be done in less than a month. So maybe at most you get a free month rent, a free month of living. Not so great because now your permanent record has an eviction on your record, and that hits your credit score. So good luck getting another apartment. In places like New York and Boston, it could be 6 months to a year to evict. With the pandemic, it's even backlogged longer. With the pandemic, a lot of evictions were put on hold indefinitely. People in their apartments for 2 years more without paying rent.
So
Then you have to shoot them, right? No. That was mean. I'm sorry.
think about what money they're losing and stuff they can do about it.
Well, or the perspective that these are tenants who are in dire straits and they need protection. But yeah,
Yeah.
so that's why that's why we don't shoot them. I mean, you shoot them, it's pretty quick, right? But that's All right. The American rule versus the Texas rule. Lloyd, save us, please. What's the American rule? What's the English rule?
The American rules more. That you're only required to give legal possession, English and modern, is legal and actual.
Good. So there's the American rule, which is the common law rule. And under the American rule, the landlord is only required to give the tenant legal possession, which means you have the bundle of sticks and that's it. That's all you get. Under the so-called English rule, or what might you call the modern rule, you have the obligation to give both legal possession and actual possession. Right? In this case, the tenant was given legal possession, but not actual possession. The court followed the American rule. Therefore, there was no cause of action to be had. The landlord did everything he was supposed to do. Again, there might be a fraud cause of action, maybe unjust enrichment. There might be something else under tort or contract, but not under property law. And just keep this in mind for property too. A lot of times when you think there's fraud, it's a contract or tort claim. It's not actually a claim based on property law. Keep that in mind, okay? All right, good. All right, questions on, goodness, you have these 2 rows are just empty. So I'm just like walking around. Yes, Clark. Yeah, it's one of these rare cases where the English rule is more modern. It's sort of the opposite of what you would think. But the American rules, I mean, what happened was in England sort of moved forward, but America didn't. Texas follows the American rule for those who are curious. Yes, Anwar.
I thought both of these rules fall under the common law, right?
We're splitting hairs, right? The more modern among the common law rules is the English rule, right? It's just in terms of recency, right? How far back do you want to go? And this case is what, 1920 something? So I mean, this is an old case by itself. Alrighty. Are you all with me? Can I move on? All right. So in this case, the tenant basically was out of luck. The most he could have done was to call the sheriff and seek an order to eject the holdover tenant by signing the lease. I think the court would have given to him, but instead he appealed this case for however many years to the state Supreme Court, and he lost. That's gotta suck, right? And he just wants to move into his damn home, his black acre. He can even move in. I think if he would have shot him, we would have a different. It'd be a case for your criminal law chapter, right? I mean, that's a good. I mean, that'd be a fascinating self-defense question, right? Do you actually own the property to use self-defense? Well, but it'd be emerging. It'd be like it'd be a combination of property and criminal law. Where is it self-defense? You have to first determine who owns the property, who owns Blackacre. Yeah.
People, didn't he have people?
Right, but if he's a tenancy at sufferance, there's a claim the other one had tenancy as well, and the court could actually have the tenants at sufferance. In other words, if the landlord created a new periodic tenancy, you could say that his interest actually trumps you know, one has the paper, the other one's actually on the property. Good bar question, right? Kyle, Trey, you're flipping your name. I know it's not your name. Thank you. Don't mess with me. I have a hard job if you're. That's a question for someone else. Yeah, don't ask me. I mean, you can ask me, but I won't answer. I don't feel confident answering your question. I'll give you an answer that's probably wrong. But you know, they do that in the bar exam where they'll merge topics, and that's actually a good question, right? Does the castle doctrine apply? Who actually owns it? And it's like a 2-level question. I mean, even harder question is what if you're leasing and you have the present interest and you have the what do you call it? The landlord comes on. Do you have any interest there? But yeah. All right, can we move on? All right, that was the first case, Hannon versus Dush. Thank you very much. Next up, subleases and assignments. Anwar, help us, my friend. What is the difference between a sublease and an assignment?
So basically, an assignment, you convey the whole term, leaving no interest or reversionary interest.
Correct. Correct. And what's a sublease?
Sublease is the tenant grants interest in the lease premises less than his own or reserves to himself a revenue.
Excellent. All right, very good. Thank you so much. I think the easiest way to think about the distinction between sublease and assignment is a bundle of sticks. I hate to keep coming back to this metaphor, but it works. When a tenant makes an assignment, the tenant conveys the entire bundle of sticks, right? When a tenant makes an assignment, he conveys the entire bundle of sticks. When a tenant makes a sublease, one second, he conveys something less than the full bundle of sticks. There's some reversionary interest, there's something left over, right? That's how I think of it. Not ideal, but that's how I do it.
You mentioned the full bundle of sticks.
The sticks that he has,
Okay.
right? It's not the fee simple. Whatever sticks he has, he gives away his full bundle. Thank you for clarifying that point. You're right. Yeah, a tenant doesn't have the full bundle, but whatever sticks he has, he gives all the sticks away to someone else with an assignment. And with the sublease, he keeps some sticks for himself. All right. So the next case, which I don't agree with, I'll just tell you up front, I don't like it. No, I think it's wrong. But the next case, what do I know? Right. But the next case illustrates how difficult it is sometimes to distinguish between a sublease and an assignment, and why the difference really does matter. So this is Ernst versus Condit. The facts here are kind of messy. Mike, I think you're up. First. Start with the facts. I might interrupt you. Maybe we'll move around a bit, but just what are the facts here? Okay. Good. Good. How long did you run the business for? Yeah, grand total of a month, right? So what were the terms of the original lease there, Mike? What were the terms of the original? Uh-huh. How long was the original lease for? 1 year. Okay. Good. And did the landlord need to give consent for a sublease or assignment under the original lease?
Yes.
Correct. Okay, good. All right. So initially, Ernst signs a 1-year lease with Rogers. Ernst signs a 1-year lease with Rogers. And the idea was, this is a new business. The rent will be either $350 or was it 15% of the revenue? So if it's a successful business, that's great. He'll make lots of money. Rogers builds, pavement. He puts on asphalt. He builds a race car track, other stuff. He makes improvements to the land. And then about a month later, he sells his business to Condit. Now, this Rogers character isn't really in the case. We don't really know much about him, but he seems to basically had all these grand visions and like quit like right away. So maybe his business wasn't so successful. We don't know. He sells the business to Rogers. And then Rogers, Ernst, and Condit reach a new agreement. They amend the lease. I'm deliberately not calling it one or the other, right? So let me just walk you through the second lease. First up, the lease was extended by 1 year. It'll now end in 1962. All right. In three places, the document refers to the lease as a sublease. Subletting, sublet, subletting, right? So in three spots, he uses the word sublease. Apparently words don't matter in Tennessee. Okay? What do I know? Right? Rogers promised to remain liable for the performance of the lease. He promised to remain personally liable for the faithful performance of all terms. Why is that relevant, Sarah? That Rogers said he will remain personally liable. What's the significance of those terms? Yeah, why?
Because when you sublease something, you still have that liability, like, to pay.
So if you're Rogers, right, and you read this term, and you're like, "Uh-oh, I can't pay my rent," what are you thinking to yourself?
Just like pass the buck on to.
Pass it to Rogers, right? The only reason that Ernst made this agreement was because Rogers personally agreed to faithfully perform the liability. So if the new guy doesn't pay rent, what happens?
It would go back to the original.
Yeah. And I suspect that Condit sort of knew this as well. It's like, well, this is a freebie for me, right? I can run this business if I'm successful. I'll pay my rent. If not, okay, I'll just walk away. And what's he do, Sarah?
That's what he does.
He walks away from his business. He just abandons it and stops paying the rent. Right? Now you can imagine Condit thought this was a sublease. Rogers thought this was a sublease. Everyone thought this was a sublease, right? But then it gets to litigation. Tristan, and what does Ernst argue in court? How does Ernst read this agreement in court? Does he think it's a sublease or an assignment?
Sublease.
Ernst, the landlord.
Oh, sorry, assignment.
Why does the landlord want this to be an assignment?
So we can collect this fund that they're basing it.
Collected directly from who? Who is? No. Who does he want to go after? The sublessee, right? Condit. It's Ernst versus Condit, right? Ernst wants to go after Condit. Where's Rogers? We have no idea. Right? He's not in the case. It's kind of weird. Maybe he's bankrupt, maybe he's just disappeared. We don't know. But Rogers is just vanished. He's not in the case. Who is in the case is Ernst and Condit. Ernst, the landlord, wants to go after the new tenant, Condit. The only way that works is if there is an assignment, right? If there's an assignment, Rogers would have given his entire bundle of sticks, everything he had, over to Condit. Now, Grant, what does... Oh, you're Grant too. Who's Tristan? He's not here. Oh, you're flipping it. You guys are messing with me. I swear, I see these name tags flipping. It's so confusing to me. I got your name right. You're Tristan. I know that. Don't mess with me, right? Okay, so Grant, let me ask you this question: What does the subless? I won't call him the sublessee. What does Condit? How does Condit want to read this agreement? What does he argue it is?
I believe he wants to read it as it is a sublessor.
Right.
And then there's three, like you said, there's 3 points in the agreement that says that.
And what will be the consequence of reading this agreement as a sublease?
Rogers would be financially liable to Ernst, and he would just be off scot-free.
Let me ask this question differently. Could Ernst even sue Condit if it was a sublease? According to at least Condit. According to Condit, Can Ernst directly sue Condit? Ooh, I'm sorry. That was bad. I'm sorry. Sorry. That's correct.
Right.
Guys, okay, I know. Lights off, right? Last question again. You got it correct.
Right.
Doing here. According to Condit, could Ernst directly sue Condit?
Not according to Congress.
Who must Ernst actually sue? Correct. He's right. I don't know if this is correct, and I don't. You don't need to have the right answer, but according to Condit, the only way this can happen is if Ernst sues Rogers, and then Roger impledes, if you will. Roger brings in Condit. I don't know if that's correct, and I'm not sure. I'm not sure if that's right, but he says primarily the responsibility is to the original tenant. Again, I'm not sure if that's right, but that's his argument. Without question, if it's a sublease, Rogers has to be in this case, right? You can't go after him just by himself, right? Now, I think this is a sublease. The word sublease is there 3 times, and he says, "I remain responsible." That seems clear to me. What do I know? Dylan, why does the court here go the other way?
In this opinion or the lower court?
Do the higher court.
They said that to be a sublease has to transfer less than the full term of the lease. And yeah, the sublease, if it transfers less than the full term, he transferred all of his interest. Did I get your question?
You're on the right track.
I mean,
Keep going. I'll ask you a follow up in a minute.
Sorry, you said it was
What's the basis of the court's ruling? How about that?
yeah, okay, there you go. It said that he transferred the full
Bundle.
the full bundle.
But did he? When he says, "I remain liable to cover their responsibilities," doesn't that seem not
That-
full?
An interest
Yeah.
in, I don't know what it would be exactly, but
Yeah.
I'd say
Right. So the court says, look, first off, this extended the lease, right? So basically, let's give all the days that Rogers had plus another year. Okay, that's fine. I'm with you on that one, right? But then they get to this sort of funny rule. They say the text of the instrument is not very important, right? It's unsound to focus on the words they chose. Did you guys kind of jump when you read that? You took contracts for a year? Is that all you freaking do? Look at the words people chose? There's actually a dissent I agree with. I read the dissent. But they say we don't really look at the words they use. Sublease, sublet, whatever. And maybe it's reasonable, right? People use words sublease and assignment interchangeably, but 3 times? These were 3 times? That's pretty deliberate in my mind. Okay. But what the important part is that Rogers parted with his entire interest. And Rogers reserved no part for himself. There's a full assignment here. Now, I don't know how you square that with this language saying, "I, Rogers, remain liable for all these responsibilities." The court basically says, well, we just sort of push that aside, right? That's not so important. That's, to my mind, the most important sentence in the entire document. And it's repeated twice, almost verbatim. So I think the court got this one badly wrong. But what do I know? I can't even count days in a calendar. Okay. So here the court said there was an assignment. Rogers gave all of his sticks to Condit. Therefore, Rogers was no longer liable for the rent, and Ernst could sue directly to Condit. Yes.
So, different from Sublease, I know more about getting full bundle. Like, I was thinking, like, I agree with the court here because
Okay.
it's an extended lease that's more than a full term.
Correct.
I was more focused on.
If they just focus on that, I think I go along with it, but the rest of the analysis, I have trouble with. Because even though they extended it, I mean, think of it this way, right? They extended a year, right? But they also said during that year, Rogers remains liable for the responsibility. So basically, they extended a year with Rogers having a stick, right? They gave him a stick for that extra year. So I just have trouble with this opinion. Not always. I mean, I can live with it, but just when I think it's probably wrong. But there's a dissent, right? And I think the dissent says this is just follow the words they chose. Okay. All right. Yes, Alexa. You can cite it. It's a case. Someone asked me the same question last class. I did not have a good answer. if I give you some document to interpret, you're welcome to cite this case as an example. Or you can say, we look at the text, do whatever you want. Just back it up. I mean, I've had exam questions say criticize this doctrine, right? Criticize this case. You're allowed to. Or praise it. Say what you like and dislike about it. You're allowed to do that. All right. Yes.
So is that, like, did you not convey all the bundle Rogers because he agreed to remain liable?
That's my view, but I'm wrong because the court went the other way.
Okay.
What do I know? All right. Yeah.
I guess when I was reading, I feel like there was more on the lines of the conduct of the party instead of what they say. So it might have been like,
Maybe the court realized that this was something going on otherwise.
yeah.
Maybe it's possible. I wasn't there. Yeah, I mean, the chancellor of the trial court maybe had some observations about the case. Rieger, then I want to move on to the next case.
Do you think it's maybe them trying to justify the policy of not creating a harm without a remedy, the landlord?
What do you mean?
I mean, in the sense that since Rogers has gone up somewhere and we don't really know.
Give him something.
Yeah.
Because Condit's here.
Yeah.
He's found. He's not. Assuming he's not judgment proof, right? Maybe he has no money. I mean, again, the amount of money they're suing over is only a few $1,000s. That doesn't strike me as a terribly large amount of money. The attorney's fees are probably greater than what they actually recovered. I mean, this case could have settled very easily. I mean, the worst thing to do is to just simply walk away and not pay your rent. It's better to say, here, let me pay you something and just let's terminate this lease. But also, I mean, think about it. They built a go-kart track on Blackacre. What are you going to use it for, right? You can't use it for something, maybe a parking lot. I don't know, right? You can't like convert that to something more useful. So they damage the value of the land, I think at least. All right. Questions then, but I think what your sort of takeaway from this case is it's often very difficult to distinguish subleases and assignments. They often have blurred definitions. So Anwar gave, I think, a good definition a minute ago, but it breaks down pretty quick. But it really matters when you decide who's in the hook for rent. Then it really matters if the sublessee flakes out. The last case is sort of complicated. Enforcers from California, so you know what's going to happen, right? Oh, I tell you the truth. It's true. Sarah. Let's do the last case, and the facts here are not pleasant. So we'll do this in a couple of different stages. Kendall versus Ernest Pesana. Okay, let's start.
Okay. So the city of San Jose leased an airplane hangar to the Pertliches.
Okay.
Then Robert Fix.
Okay.
But they also assigned or they assigned interest.
Who's they?
But they also assigned their interest in the city.
What interest do the Pertliches have?
So very limited interest.
No, that's not right. They had an interest. Let's break this down one step at a time, right? So there's a hangar at an airport in San Jose. It's not too far from San Francisco. Okay, the city owns it. The city gave a lease to the Pertliches. We don't know how long this lease is for. Let's just say it's 50 years, right? It's a long lease. The Pertliches subleased the hangar to Bixler, right, Sarah?
Yeah.
For 25 years. What interest do the Pertliches retain for themselves? If they gave a sublease to the Bixler, and let's say it's a 50-year lease they had, what did they retain for themselves? What do you call that? It's a reversion. Why is it a reversion?
Because as soon as the sublease is over, it
Naturally goes back, right? So there's actually two reversions here, right? First off, the city has a reversion. When the lease of the Pertliches expires, it goes back to the city. The city has a reversion. But the Pertliches also have reversion. After the 25-year sublease runs out, it goes back to the Pertliches. Bree? It's a reversion in leasehold. It's not a reversion fee simple. It's reversion in leasehold, specifically a term of years. right? For whatever number of years remaining. So let's say it's a 50-year lease, it'd be reversion for 25 years. Yeah, it's a weird phrase, reversion in it's reversion in term of years. If you want to be precise. Yeah, thank you, Trey. It's reversion in term of years for whatever the duration of the period is. You can do that. You can do reversions in fee simple, reversions in leasehold. You can do all that. But there are two reversions, right? The city has reversion fee simple for the city, and then the privilege is reversion in term of years. I think that's right. Okay, thank you, Sarah. Very good. Back down to Cade. All right, so the privileges had a reversion in term of years. What did the privileges do with their reversion?
So they gave it to Ernest Pesana Inc.
Okay, let me just pause right there. The privileges gave their interest to Pestana. Was it an assignment or a sublease?
They assigned it.
Okay, so now we're gonna get messy, right? The privileges assigned their reversion in term of years to Pestana. I think I said that right. The privileges assigned their term of years. I'm sorry. The privileges assigned the reversion in term of years to Pestana. Okay. So now effectively, Pestana stepped into the shoes of Perlich, right? Perlich was out. They gave an assignment. They had no further interest in the hangar. They're out. So what Perlich was, not Pestana. The relationship is Pestana here and a Bixler over here. All right, Monet. What happens next?
They disagree with the assignment.
Not yet. So the Perliches assign their reversionary interest to Pestana. What happens next? What does Bixler do? What does Bixler do? Not yet. You're skipping a step. What's the name of this case, Monet?
Kendall,
Who's Kendall? Don't say Jenner, right? Who's?
okay.
Oh yeah, you're missing. Okay, so what happens next?
So they assign
Who's they?
Bixler.
Bixler. Okay.
Bixler sells his interest to
What does he sell to Kendall?
the Lease.
Can he do this by himself?
Doug has to get permission.
Okay, just to clarify, Bixler sells his business, his airplane business, to Kendall. But he needs to do something else, Monet. What does he need to do to make this transaction work?
He has to get approval through the approval call.
Okay, now we're talking. Okay, good. So Bixler goes ahead and sells his business off to Kendall. And with that business, presumably would come the property, the airplane hangar where they do repairs and stuff. The original lease between Perlich and Bixler says that the landlord must approve of any sublease or assignment. Right? So Tamika, let me ask you a question, please. What is the reason why Pestana refuses to give consent?
Oh, like there was no good reason. It was just, I don't want you to do this.
What was actually Pestana trying to get out of this? What were they trying to extract from Kendall?
Increased rent.
Bingo. Exactly right. The reason why Pestana withheld consent was that Pesana wanted to jack up the rent. He's like, okay, you want me to agree to this assignment? Hey, pay me more money. All right. Clark, let me ask you this question. Under the majority rule, could Pestana make this sort of demand?
Oh yeah.
Why?
The traditional rule is that you can just arbitrarily choose to.
Correct. Under the majority rule, which was in effect in most states, a landlord could deny consent for any reason or no reason at all. The justification did not have to be reasonable. But we're in California, right, Sophia?
Yeah,
And what happens in California?
things get reversed or in the minority rule.
And which rule do they adopt here?
So they go with the minority rule.
Of course they do, right? What's minority rule here?
So a lot landlord can withhold consent under the commercial.
Good. So the California Supreme Court says, well, we have a rule here. That's nice. Let's do a new rule, right? So they follow the minority rule. And under this minority rule, the justification to withhold consent must be reasonable. There's a reasonableness standard. Now, what does reasonable mean? Who the heck knows? But at least that gives the court a power to say, you need to give a better reason than you already gave. Trey?
Clauses in the sublease, like we have to get consent, like those clauses.
Mhm.
Are there some states that don't require that? Like, won't uphold those?
You mean they find them unenforceable? I'm not aware. I'm not sure. Tony?
Reasonable, like not a moral compass or reasonable, but maybe like a contract.
It's a commercially reasonable standard, I think.
Right.
It's like a commercially reasonable standard.
Doesn't leave out too much interpretation, does it? Or
I think it's pretty open-ended, right? I mean, what if the landlord says, I don't want his business because I've heard that he's not been good to clients. He's got complaints with the state. That might be good. It might not be. In this case, I think everything was kosher, right? All the tenants were lined up. Everything was good. But you can imagine a borderline case, it's a lot harder. Right. The advantage of the majority rule is the courts don't care, right? If the tenant says no, that's into the story. But with this minority rule in California, the court would actually have to have a trial, a finder of fact, would have to determine, is this commercially reasonable? And that's a hard question. You're really rolling the dice, right? If you're an attorney for the landlord here, do you withhold consent, or do you just give it because you're afraid you might lose in court?
I didn't really understand what commercially reasonable standard, because wouldn't it maybe be commercially reasonable for one party but not the other?
It's very subjective. Look, I mean, you guys took torts for a year, right? The reasonableness standard is not easy. It never is. But what the court's saying here is it's not going to be unilateral. A court will decide after the fact, was this a reasonable justification? Daniel?
Increasing rent and commercially reasonable.
Unreasonable, right? The court says if you want to increase rent, you should negotiate a new lease. You can't just impose upon them sort of as leverage to do it. I mean, think about it. Bixler sold his business, and this dispute held up the entire sale of the business, because until you actually transfer the business and the property, you can't run it. To another hand. All right, so the court here adopts the minority rule. It's California. That's what happens. And the court says, if this was so important, you can negotiate for an absolute clause. It says, we can withhold for any reason whatsoever. And I suspect the court would then say that's an unconscionable term if someone makes something else up, right? But in theory, at least, you can negotiate for a term saying you can withhold consent for any reason at all. And they say this should not come as a surprise. Stare decisis for suckers, as they say. It's a meme, right? Should not be surprised. There's been a trend towards this minority rule. Again, if you're a lawyer in California in the 70s and 80s, I think you have basically a moral obligation to anticipate the law being changed, right? So if you're advising your client, right, imagine you're the lawyer, right, for Pesana, and he's like, so do I have to give a reason? And he's like, no, you don't have to give any reason. That's the rule. And you just give him advice that gets overruled at the court. I mean, you have to say, well, under the majority rule that the state adopts, you're not required to give any sort of reason. But this court, man, they're going to change things up on you, so you might want to just play nice. And that's the advice you might have to even give. I mean, it's not a crazy thing to think about. If you're a lawyer in the state, when the court says it should not come as a surprise, it's like, well, you should see where we're going. Had to go to the state Supreme Court to overrule precedent, but sucks for you that you didn't see this coming. And in this case, there was a dissent that says stick with the majority rule, go with the terms as they see fit, and don't inject yourself in the process. Okay. Questions on Pesana? All right. So I think the important part of this case is not so much actually the California court reversing it. Why I actually like this case is it forces you to keep track of who has the present and future interests, like the thing I did with Sarah and with Monet and Cade. That's actually very important. If you were able to track the facts of this case, you get leases. That's actually more important than the outcome of the case. I actually really like the complicated fact pattern. All right. So let me wrap up a bit. I hope you understand how to count 30 days. If you don't, come talk to me. But for today, you have to know the difference between the American rule, the English rule. With the English rule, it's the right of both occupancy and legal right. Both the American rule, only legal right. Assignment for sublease, full bundle 6 versus partial bundle 6. And California, they're going to reverse the common law. That's the rule. All right, anything else? All right, I will see you all in class on Tuesday. Have a blessed Passover if you're celebrating, and I will see you soon. And good Easter as well. Good Easter as well. Sorry, the other one.